Hello. Hello. Hello, my student. Hello. Uh, Today is going to be another day for the lecture online. Okay, so the topic we're just going to be for the lecture today. It is still the legal issues in the e-commerce, okay, or legal issues in electronic transactions law in Thailand. Okay, so if you can remember well, okay, last week we have in fact, okay, seen legal principles regarding the e-commerce or e-transactions law in this country. Okay, as you are now well aware, I hope. Okay, we in this country in Thailand we have the so-called the electronic. Okay, we have the so-called Electronic Transactions Act 2001. And again, for short, we are going to call this act the ETA. Okay, so we have ETA for about, almost 20 years. Okay, so from the 2001 up to 2021. In fact, 20 years. Okay, but the act of 2001 has entered into force in March 2002. Okay, so I think that it's going to have. It's going to be 20 years old, in a few months' time. Okay, so as we have seen, even though this act has been in force for about 20 years, not many people have in-depth proper understanding of this law. Okay, so we have seen that the laws intends to treat two things equally. Remember, the first thing is the traditional means of communication. Okay, put simply, it refers to communications on the basis of paper-based documentation. Okay, the second thing is the communication by electronic means, i.e., by the use of data messages. Remember, we have in this act the so-called functional equivalent, okay, under which, okay, the transactions which are made in a paper form are treated by law, okay, equally as in the same way as transactions which are made in the form of the data messages. If we, for instance, make a contract in a form of paper, and that contract functions, okay, in the sense that it is valid, it is enforceable, then the same contract can be made in the form of a data message. Okay, a contract which is made in the form of a data message will have to be treated in the same way as a contract which is made in a paper form. There must not be any differences, okay, in terms of legal consequences or legal treatment between the two. Okay, the two that's made between the use of paper-based documentation and data messages. Okay, we have seen also that in many contexts the law requires, okay, that we comply with some minimum requirements. Okay, so if in those contexts, if we want to use data messages in the making transactions, we have to make sure that we accept minimum requirements which are imposed by law. Remember, there are the context of what? There are contexts regarding writing or written evidence. There are also, there is also the context regarding the signature, right? I think that we have seen this at great length, okay, in our previous lecture. Today we will look at the remaining issues. Okay, we are going to proceed to the other context. Okay, beginning with this one, original. Okay, so that we can see that in the many cases, the law requires us to present, okay, or to produce documents in the original form. Okay, so if the law requires us to present or retain, okay, any information okay, in its original form, the question arises as to whether or not, okay, if the law requires us to retain or to present, okay, information in its original form, can we, okay, retain or present that information in the form of data messages? That means that, okay, if the law requires us to present or to retain okay, any information, okay, any document, then can we use a document? Can we retain or can we present a documents in place of, in place of manually prepared document? Okay, so that is the question. Okay, we can say that, well, if we give legal recognition of data messages, the answer to this question should be yes, right? If the law requires us to to present or to retain any information in its original form, then we should be allowed by law to present or to retain such information in the form of data messages. Okay, I think that this seems to be something necessary. Okay, if the law allows us to use data messages in place of paper, and the law does not allow us to retain, okay, or present information in the form of data messages, where the law requires the presentation or retention, okay, of any information in any form, then it's going to be a problem. Okay, so this is why we now have the law in this country, in Thailand. We have the ETA. Okay, we have Section 10 of the ETA, which provides as follows: in the case where, the law requires that any information, in the case where the law requires that any information be presented or retained in its original form as an original document, if the presentation or the retention is made in the form of a data message in accordance with the following rules, it shall be deemed as the presentation. Okay, it can be deemed as the presentation or retention of the original document under the law. Okay, A at 1 and 2. That means that 1 and 2 here, they are what? What is said in 1 and 2 here? Okay, represents what? What is said in 1 and 2 here constitute minimum requirements, okay, imposed by law. Okay, put simply, what is meant by this section 10 here is that if you come across any law which requires you to present or to retain any information in in a document form, right, or in a normal form, right, then you are welcome. Okay, you are permitted by law to present or to retain that information, in the form of a data message. You are allowed to present or to retain the e-documents in place of the normal documents. Okay, so provided that you observe the requirement in 1 and 2. The requirement in number 1 is this: that a reliable method is used, okay, with that data message for ensuring the integrity of the information, okay, from the time when it was generated in its final form. This means that, well, you need to have some technology. You need to have some method, okay, which preserve the integrity of the information. The word integrity here, that means that it is a state of not being altered. It is a state of not being changed in any way. Okay, so if the law requires you to present or to retain any information, you're welcome, okay, to present or to retain that information using data messages. That means that you are welcome, okay, to present or to retain e-documents, okay, in place of normal documents, provided that you follow the rules in 1 and 2. The first rule is that you need to use a reliable method which keep the integrity of information. You may, for instance, use some software which can prevent any alteration of this data. Okay, otherwise you will not you will not fulfill the minimum requirements with respect to the first one here. Okay, the second one is that the information is capable of being subsequently displayed. Okay, so even though you use e-documents, even though you present or you retain e-documents in place of normal documents, okay, you need to make sure that the information, okay, in that e-document, okay, is capable of being subsequently displayed. Okay, so maybe the method which you use for presentation or retention of that information. Okay, it must be it must allow the information to be subsequently displayed. Okay, so these are the two requirements set by the ETA. Again, this provision in our ETA, it is not a local product. Okay, it is not the product which is locally made, but it is the product of what? The product of replication from the Astro Modelo on e-commerce. Okay, 1996. Okay, we in fact in this country in Thailand, we have drafted section 10 here along the line of Article 8 of the Astro Modelo on e-commerce. If you look at Article 8, you will see that the wording seems to be quite the same. Okay, according to Article 8 here, where the law requires information to be presented or retained in its original form, that requirement is met by a data message if A and B. Okay, A is what? A directs a reliable assurance as to the integrity of the information from the time when it was first generated in its original form as a data message or otherwise. Okay, and B, that B is the requirement number 2. Okay, where it is required that information be presented. Okay, that information is capable of being displayed to the person to whom it is to be presented. Okay, so the diversion just differs from the Astro version a little bit. Okay, but in essence, it does not so much. It does not. It is not so much different. Okay, even though there is a slight difference between the Thai version and the Astro version. Okay, so put simply, what is meant by what is meant by what is meant by Section 10 or by Section 10 of Thailand's ETA, or by the Article 8 of Astro Modelo on e-commerce is that if you come across any law which requires you to present or to retain any information, you are now allowed by law, to present or to retain that information, in the form of a data message. Put simply, you are now allowed by law to, present e-documents or to retain e-documents, in place of normal documents where the law requires you to present or to retain any information. Okay, so this is something which seems to be very, very, very simple anyway. Now we move forward to the one more thing here. Okay, one more thing here: retention of documents. Okay, just now we talk about original or originality. Now we are going to talk about retention of documents. Okay. In many cases, the law requires us to retain or to keep some documents. Okay, so I think I am going to give you one example in Thai law. In Thai law, we have the law known as the Accountancy Act. Okay, the Accountancy Act of 2000. Okay, according to this act, the persons who are specified by law, normally they are accountants. Okay, they are accountants. Accountants will have to do what? Will have to keep, they will have to keep financial documents. Okay, for them, let's say for 5 years. If the law requires us to keep some documents, can we keep those documents in the form of data messages? Let's say that this act, the Accountancy Act in this country allows accountants to keep financial statements for a period of 5 years. Normally when we prepare the financial documents, we may use, let's say that we may use Microsoft Excel to prepare our financial documents. You may use some other application, like if you use iOS system, okay, you may use the numbers application on your MacBook or your iPad, okay, to prepare financial documents, okay. So you can save the files in the you can save the files as computer files. Now you have financial statements not in the form of paper but in the form of company files, or put simply in the form of a data message. If you prepare the financial statements in the form of an Excel file, or a number file, okay, prepared by the MacBook, okay, that's all by your iPad, okay, are you regarded by law as if you want to keep those files, the company files, in place of the normal paper, in place of normal paper, okay, are you regarded by law as keeping documents as required by law? Okay, so put simply, can you just retain information in the form of a data message in place of the paper form? Okay, if the law requires you to keep some documents, I mean the answer should also be yes, right? But the law requires you to observe some the minimum requirements. Okay, so in this case we have the provision of Article 10. Article 10 of the Transformational law on e-commerce again. Okay, according to Article 10, if you look at the heading of Article 10, okay, it is retention of data messages, right? According to this Article 10, where the law requires that certain documents, records, or information be retained, that requirement is met by retaining data messages. See, that's mean that if you come across any law which requires you to keep any information, okay, you are now allowed by law, okay, you are now welcome, okay, to keep that information in the form of data messages. You may, okay, put simply, you may use e-documents in place of normal documents, okay. If you keep e-documents, then the law will regard that you have duly complied with the legal requirements with respect to the retention of that information, okay, provided that, okay, the following conditions are satisfied: A, B, and C. So A, B, and C here, there are what? There are again minimum requirements which you have to observe if you want your e-documents to be, if you want your retention of e-documents to be regarded by law as the retention of information as required by law. Okay, you have to follow the rules in A, B, C. Okay, the rule in A, B, C. I'm not going to go through all the rules here. I'm going to just give you an example. Okay, look at the example. Look at the rules in the B here. A, B, C. Now we're going to look at B here. Okay, if you want to retain, if you want to keep information in the form of a data message, you need to do what? You need to make sure that the data message is retained in the format in which it was generated, sent, or received. Okay, that means that you need to use any method, okay, which retain the information, okay, in its original format, in the format in which it was generated. That means that in its original format, or in a format which can be demonstrated to represent accurately the information generated, sent, or received. You have choice 1 and choice 2. Okay, choice 1 and choice 2. If the law requires you, let's say that the law requires you to keep a financial statement, you are welcome, okay, to keep that financial statement in the form of a data message. Let's suppose that, okay, you keep your financial statement in the form of an Excel file, then fine, but you have to just make sure that okay, that Excel file is what? That the information, okay, in that file, okay, it is retained in its original format or in a format. Number one is that, in this original format. Or number two, this is a choice. Choice number two is that you may just keep that document. Okay, you may just keep that e-document in a format which can be demonstrated to represent accurately the information generated, sent or received. That means that, well, it does not need to be in its original format. Okay, but it needs to be retained in a format which can display the content of that, the e-document accurately or correctly. Okay. Why does the law give you two choices, choice one or choice two? With respect to choice two here, okay, that is the way to accommodate the situation where people do not keep e-documents in the first place, but the people just keep documents in a paper form in the first place. But later, people just transform the paper form document into data messages. Let's suppose that, back to the example here. The law in this country, we have this law in this country, the Accountancy Act. In Thailand, the Accountancy Act requires, require an accountant, some accountants, okay, to keep the financial statements, okay. So you are welcome, okay, to keep that financial statement in the form of data messages, okay, in the form of a data message. Okay, let's say that you keep it in the form of an Excel file, okay, or in the form of a computer file. Then it's very, very well. You may just keep your, computer file in place of, the paper form financial statement. You don't need to keep paper. You may just keep your financial documents, okay, financial statements in the form of an Excel file, okay. But sometimes, okay, you may not, you might not keep, the computer file in the first place. You may decide to prepare your financial statements in a paper form, but later you may just, convert that paper form into a data message. Let's say that, you have, you have your financial statement in the form of paper now. Let's suppose that I'm going to get a paper for you here, okay? Let's suppose that now. Okay, now I have this paper, okay? Let's suppose that this is your financial statement. At first, you prepared your financial statement in this paper form. Okay, you did not prepare it in the form of a data message in the first place. You prepared it in the form of, in a paper form like this. But later, you just would like to transform this paper into a computer file. Well, you may do so in many ways. For instance, you may use a scanner. You may just feed this paper, okay, into a scanner in order to get, let's say, a PDF file. Well, there are so many different software. There are so many applications, okay. So there are so many methods for transformation of paper into Commodify. Scanning is one of the methods, okay. Sometimes, it is possible that your software or your applications may just change some appearance of your data, okay. Without changing any contents, the appearance may be changed. Let's say that, when you prepare your financial statement, okay, in a paper form, you may use this font, you may use one font, but when you just get it scanned into, into a company file, sometimes your software may convert, okay, or may change the font, even though the fonts on your original paper is now changed. When you just convert, the paper into a computer file, sometimes, the fonts can be changed, but the content of the paper document remains intact. So according to article 10 here, say, don't worry. We know that. I mean, sometimes there are some methods by which you can transfer paper into Commodify or into data messages, and we know that software or some technology which which people use for conversion or for transformation of paper into computer files, just make some change to the appearance of the paper, okay, without changing what? Without changing the contents on that paper. So even the fonts are now changed, but okay, the contents of the information, okay, the contents of this document are not altered in any way. So if you just convert or transform the paper document into the e-document, okay, even though some outer appearance is varied, it doesn't matter, okay. If the information can be displayed, if the information here, it means contents. If the contents can be displayed accurately, then fine, okay. You are regarded by law as having duly, okay, retained the documents as required by law, okay. So again, if the law requires you to keep or to retain, okay, financial statements, you are welcome, okay, to retain data messages in place of paper documentation, okay. You may just prepare your financial statements in the form of data messages in the first place. For instance, you may just prepare your financial statements using what? Using Excel application, okay, on Microsoft, on the mic on your computer. But you may also you may prepare your financial documents in the form of paper, but later you may just transform that paper document into into an e-document or into a data message. Then fine, you need to make sure that the software or the method which you use, okay, for retention of e-documents, okay, it is the one where the contents, okay, can be displayed accurately. Then fine. So we can see that, okay, when the law gives you two choices, choice 1 and choice 2, right? Choice 2 here, choice 2 which say that, well, you may just retain your document, okay, in a manner which can just display the content or the information accurately. This is what? Choice number 2, it is designed to do what? Choice number 2 here, it is intended to respond to digitization. That means that is to respond to the situation where people, okay, do not use data messages in the first place. People may just use paper like this, normal paper in the first place, okay, and later they may just transform paper into e-documents or into data message, okay. So they may just keep, okay, the information in the form of normal paper like this, but later they just convert the paper documentation into e-documents, okay. So this is the situation of what? Situation of digitization, okay. So in the case where you convert paper into a data message or into a computer file, okay, if the law requires you to keep any information, if you just keep that e-document, okay, in place of normal paper documentation, then you are regarded by law as having duly observed the legal requirements with respect to the retention of information, okay. So that is something to be, okay, to be clear, okay, to say that now, right, from the requirements, okay, with respect to article 10 here, okay, in relation to retention of data messages, okay, when the law gives you two choices like this, it is what? It tells us that, in fact, this model law, okay, this model law on e-commerce applies to these two scenarios. These two scenarios, okay, the first scenario and the second scenario. The scenario number one, the scenario number one, it is, the scenario in which transactions are made by data messages from the beginning. And the scenario number two, it is the one in which transactions, okay, transactions are not made in the form of data messages in the first place. They are made in a paper form in the first place, but they are converted, okay? They are converted, or they are subsequently transformed into data messages, okay? So this model law on e-commerce applies to two scenarios. The first one is the one in which you make your transaction in the form of a data message in the first place. The second scenario is the one in which you do not make your transaction in the form of a data message in the first place, but you make your transaction in a paper form, okay, in the first place. But later, okay, you just transform, okay, the paper document into a data message. Okay, let's suppose that I may just prepare this contract in the paper form like this. Okay, but later I just convert this contract, the paper form contract, into a Commodify. Okay, so if I do this one, right, I am in the scenario number two. Okay, so the model law on e-commerce also applies to this scenario. For instance, when I don't have this paper anymore because I have transformed this paper into a message. Maybe I just transform this paper into a computer file. Maybe I can just get this the paper contract scanned in order for me to have a PDF file, okay? And I may just keep this PDF file, on my database. Maybe I may keep this on let's say iCloud, okay? Let's suppose that, okay, I want to bring any legal action against let's say that I'm the seller, okay? I want to sue the buyer. I want to sue somebody who does purchase goods from me without making making payment, okay? The law say that if I want to sue the buyer, I need to have what? I need to have written evidence in support of this contract. Okay. At first, I had this paper form contract. Okay. But later, I just transformed this, paper contract into a computer file. Right. In this case, okay, let's say that I don't have paper anymore because I just discard this paper because I now have a computer file in place of the paper. Okay. So if I want to sue the buyer, okay, can I just say that, well, my computer file, which is now on my database, it is written evidence in support of this contract. Can I make use of, any provision in the model law here, or if we refer to the ETA of this country, can I make use of, Section 8? The provision of Thai law regarding writing or written evidence, okay? Even though I am in the scenario number 2, okay, the scenario in which I did not have a committed file in the first place, I just had the paper contract in the first place, but I just transformed this paper contract into a committed file. In this case, the ETA, okay, Section 8 of ETA also applies to this case. I may just say that, well, my Commodify, it is, okay, it has the legal status of drafting or written evidence, okay. So put simply, the ETA applies to two scenarios, 1 and 2 here. I'm going to just make this clear because we are going to look at, one provision of law later in this country, section 12/1. 12/1, okay, it is misconceived by the legislature, okay. We are going to go through that later, okay. I just get this clear first, okay. The fact that, the money law on e-commerce applies to these two scenarios, it is clear from our, our what? Our looking at, the Article 10, okay, when the Article 10 of the money law on e-commerce just gives two choices, okay. I explained to you that choice number 2 here, okay, it is the way to respond to, the digitization scenario, okay. Now, okay, you can see if we go back to, the Article 10 here of the money law on e-commerce, which, okay, has been implanted in Thailand as what? As mean the section 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 10 here, right? We can see already that when the law requires us to retain, okay, the data messages in place of paper, it is going to be very handy. It is very, very useful because we do not need to keep, the paper documentations anymore. We can just keep data messages in place of paper documentation, okay, where the law requires anyone to keep any documents, okay. You don't need to have physical, physical space like this. You don't need to just, keep your paper documentation on shelves like this anymore. I think that nowadays you don't have so much space like this. If the laws require you to keep financial statements for a period of 5 years, you don't need to have too much space like this, okay, to keep your financial statements, because you can simply keep financial statements in the form of a data message. You may keep Excel files, you may keep the paper, you may keep the computer files in place of paper, okay, so that you may keep your documents, e-documents on your maybe on your mobile phone like this, because nowadays the mobile phone like this has a lot of space. Let's say that now I have I have iPhone here. My iPhone has the storage of 512 gigabytes, okay, so that I can keep a lot of e-documents. So if the law requires me to keep financial statements for a period of 5 years, then I'm allowed to keep what? I'm allowed to keep Excel files, okay, on my mobile phone, okay, in place of keeping the financial statements in the paper form and put all the statements on shelves like this. Okay, now business organizations, let's say SMEs, okay, they do not need to use a lot of physical space. You can just use them in a very small building, okay, to run your business, which can just bring you an annual profit of, let's say 100 million baht a year. Then fine. Okay, you can just use a very small building, okay, a very small block of building to run your business, okay. So if you just have too small building block like that, you simply do not have so much space like this for keeping your documents, okay. But it doesn't matter, because now the law allows you to keep any documents in place of normal documents, right? So that now you're cherished by the ETA, you're cherished by the money law on e-commerce, because you can go for the so-called electronic archiving in place of normal document archiving, okay. Right, now when the law allows us to use e-documents in place of normal documents, okay, in order to make transactions. Okay, remember, the law is based upon the what? The law is based upon the functional equivalent rule, okay, that in the way that now we are permitted by law to just go to just go for what? To just go for databases just in place of paper. When we make transactions, okay, we may just make that transactions in the form of a data message. So when more and more people, switch from normal documents into e-documents, that means that, okay, when people make transactions in the form of data messages or in the form of e-documents, increasingly, the use of paper is now more and more replaced by the use of data messages. Okay, when many transactions are made in the form of a data message, that means that if people have disputes, then when they would like to just bring litigation, okay, when they would like to bring, let's say, that legal proceedings against anyone, they do not seem to have the paper as evidence anymore, because they use data messages in place of normal paper, so that they can't produce or they can't adduce paper as evidence, simply because there has been no paper, okay, for that transaction, or there has been less and less paper for transactions which are made by the people. So the question arises as to whether or not we are allowed by law to adduce, the data messages as evidence in the course of law, or in any, legal proceedings. Okay, let's say that in arbitral legal proceedings. Okay, so the answer should also be yes, because it's going to be very weird if the law allows us to, to switch from paper to data messages. Okay, and the law does not allow us to produce or to adduce, okay, data messages as evidence. If the law allows us to switch from paper into data messages, the law should also allow us to adduce data messages as evidence in any legal proceedings. Okay, so that's why now, if you look at again the Untitled Money Law on e-commerce, we can see that we have Article 9 here. Article 9, which, okay, talks about what? Admissibility and evidential weight of data messages. According to Article 9 here, okay, I'm going to read the wording here, okay. In any legal proceedings, nothing in the application of the rules of evidence shall apply so as to deny admissibility of a data message in evidence. That's mean that, well, that in any legal proceeding, okay, again, we're going to just have a read again, okay. In any legal proceeding, nothing in the application of the rules of evidence shall apply so as to deny the admissibility of a data message in evidence on the sole ground that it is a data message. Meaning what? What is meant by this is that, well, from now on, okay, given that we make use of data messages in place of paper, so when we have any legal proceedings, we are allowed by law to just produce or to just adduce, okay, such data messages as evidence, whether in court or in any legal proceedings. Okay, nobody can just deny the admissibility into evidence of a data message. Nobody can just say that, sorry, you cannot, adduce your e-documents or your data messages as evidence, because when you make your transaction, you did not make it, okay, in the form of paper. So we are not going to allow you to just produce or adduce data messages as evidence. Nobody can say this. Nobody can say so. Okay, so from now on, okay, the law allows us to adduce, okay, data messages as evidence in court or in any legal proceedings. Right. So in this country, okay, we also okay, the implants, okay, the Article 9 of the model law on e-commerce into the Thai ETA. So the provision of the Thai ETA has emerged, okay, as Section 11. According to Section 11 of our ETA, okay, the admissibility of a data message in evidence shall not be denied in legal proceedings, be it in a civil, criminal, or any other case, on the sole ground that it is a data message. So nobody can just reject, your data messages as evidence. Nobody can just say, sorry, you cannot just produce your data messages as evidence because it is the data message, okay? It is not the paper. It is not in a normal paper form. Nobody can say this, okay? So nobody can deny, okay, the data admissibility of a data message in evidence on the sole ground that it is a data message. But even though the law allows you to adduce or to present data messages as evidence in any legal proceedings, it does not mean that the court or the court or the trial of the case will simply believe in the data messages which you adduce, okay? Because the law also says that in assessing the evidential weight of a data message, so as to conclude whether and to what extent it is reliable, regard shall be had to the reliability, okay, of of many things, okay, including the manner in which or the method by which the data message was generated, okay, and regard shall be had to all relevant circumstances. This means that even though you are allowed by law to adduce or to just present data messages as evidence in court or in any legal proceedings, but the court or any trial of the case, okay, can just exercise its own discretion to assess the weight of evidence. They can just believe that evidence, or they can just they can just say that, oh, we do not believe in your evidence, okay, because it is not quite reliable. So, okay, if we adduce any data messages as evidence in any legal proceedings, we need to make sure that, okay, those data messages are reliable, because the weighing of evidence, that is the sole discretion of the court or of the trial. Okay, paragraph 2 here just confirm that the assessment of evidential weight, that is the discretion of the court or the trial of the case. Okay, so if we want the court or if we want the trial of the case to believe in our data messages which we adduce as evidence, okay, we need to just prove, okay, that maybe by way of by way of an expert witness, we need to prove that our data messages are reliable. Okay, so the court or the trial of the case will have to look at all relevant circumstances. So to conclude, now the law allows us to adduce data messages as evidence, but the trial of the case, be it the court or be it the arbitral tribunal or the any others, okay, they can just what? They can just exercise their own discretion, okay, in the assessment of the evidential weight of the data messages which are adduced or which are produced, okay, by us. Right. Now we are going to turn into something which is very important, okay. We're going to turn to what is known as digitization. Okay, what is meant by digitization? It is the transformation of paper into a data message. Okay, if you get paper here, you may just transform or convert, paper documentation like this into data messages. Let's say that we can just get paper scanned into a PDF file. Okay, so in doing so, okay, we are digitizing, okay, the documents. Okay, we are turning normal documents into e-documents. This is the digitization process. Okay, the reason why I talk about digitization process is this: our ETA, or the e-commerce law as prepared by Astro. Okay, in fact, the e-commerce law, the model law on e-commerce as prepared by Astro, or the ETA of this country, applied to both scenarios. In the first scenario, this is the one in which persons make transaction in the form of data messages in the first place. Let's say that they make contract in the form of data messages. They may just make contracts by exchanging, the email messages. They may make contract by, the visiting websites and filling the form, okay, and send messages through websites, okay. So in this scenario, transactions are made in the form of data messages in the first place. But we also get the scenario number 2, the one in which persons make transactions not in the form of data messages in the first place, but in the normal document form, okay, in the normal paper form. But later, persons just convert or transform, okay, the normal documents into e-documents. Put simply, they transform, okay, paper into data messages, okay. Let's say that if we talk about, the second scenario here, okay, if we talk about the second scenario here, let's suppose that I make a contract with you and we both make contract, okay, in the paper form like this. We may have, the paper document like this. Okay, but let's say that my company is turning into, the paperless environment. My company may launch the paperless, okay, policy. So that I, as the MD of this company, I try to do what? I try to just convert all paper contracts into data messages. Maybe I get all paper contracts scanned into PDF files, and I store all the PDF files or computer files on my server or on my mobile phone like this. Okay, nowadays mobile phones, they can be equipped with quite large storage. My iPhone here, okay, that has the storage of 512 gigabytes, so that I can store a lot of the computer files, so that I may just scan all the paper contracts into PDF files, and I just keep all these PDF files containing my contracts on my mobile phone. Okay, this is also something in operation nowadays. Okay, so when we deal with the second scenario, the question arises as to whether or not the model law on e-commerce or the ETA also applies to this scenario. The answer is yes. Okay, remember that we have looked at too many provisions in ETA. We have looked at many provisions of the model law on e-commerce. We talk about the provisions regarding what? Regarding, let's say, writing or written evidence. We talk about provisions regarding signature. We talk about provisions regarding retention of documents, retention of information in the form of data messages, right? We talk about the provision regarding what? Regarding original. All these provisions of law applies to both scenarios. The scenarios in which transactions are made in the form of data messages in the first place, right at the beginning, and the scenario in which transactions are made, in a normal paper form, but the normal paper documents are transformed into data messages later. Okay, so the ETA of this country, okay, as with the ETAs or the e-commerce law of other countries, should apply to both scenarios. If I made a contract, in a paper form like this, and let's say that this contract, it is, that a contract of sale of something which is worth, which is worth at least 20,000 baht. Thai law says that, for a contract of sale of something which is worth at least 20,000 baht, okay, this contract needs to be what? This contract is required by law to be supported by written evidence. Okay, at first I made this contract in a paper form, and later I just launched the paperless policy, under which my company gets all paper contracts into, get the all paper contracts scanned into PDF files, and then those PDF files are now stored, okay, on the database. All the paper documents, including paper contracts, have now been discarded. No longer, they're no longer retained by this company, because we now launch paperless policy. So let's suppose that I want to sue the buyer. Our law in this country, in Thailand, requires that this contract be supported by by what? By written evidence. So the question which arises is whether or not a PDF file which I now store on my computer is written evidence in support of this contract. So can I just sue the buyer? When I sue the buyer, okay, can I just produce this PDF file as written evidence? Can I say that this contract is duly supported by written evidence, even though I don't have paper anymore, but I have data messages, okay, which have been converted or transformed from in fact paper, okay? So in this case, can I say that, well, even though I have a PDF file containing this contract, this is also writing, this is also written evidence. This PDF file, okay, it is regarded by law as writing or written evidence, because we can just make use of the provision of the model law, okay, regarding what? Regarding writing, or we can make use of the provision of Section 8 of Thailand's ETA, which says that a data message is regarded as writing or written evidence. Okay, so the answer is that yes. In this case, okay, I did not make this contract in the form of a data message from the beginning. I just made a contract in the paper form at the beginning, and I transformed this paper contract into a data message here, into a PDF file. Okay, so the ETA, including Section 8 in the Thailand's ETA, also applies to the scenario, so that this PDF file should be regarded by law as what? As written evidence for the purpose of this, for the purpose of, enforceability of this sales contract. Okay, so in all countries, okay, the perception is like this. The perception is that the e-commerce law or the ETA, or the e-transaction law applies to both scenarios, the one in which transactions are made in the form of data messages right from the beginning, and the scenario in which transactions are made not in the form of data messages from the beginning. They are made in a paper form right at the beginning, but the paper documents, okay, are transformed into data messages, right? But the thing is that when Thailand's ETA has been in operation, okay, for more than 10 years, okay, it underwent the amendment, okay, by the Act number 2. And the Act number 2, they put forth the new provision, Section 12/1, okay. Before I go to, the wording of 12/1, let me just explain to you like this, okay. it was felt at that time, and in fact, that is great misconception, okay? It was felt, it was believed that the ETA would apply only to the scenario number one, i.e. the scenario in which transactions are made in the form of data messages in the first place, but it would not apply to the scenario where transactions are made in a paper form, but paper is later transformed into a data message. Put simply, it was believed at that time that our ETA would not apply to cases of digitization, okay, where transactions are made in in the paper form, and the normal paper is subsequently transformed into a data message. It was believed, and in fact, it was such great misbelief that the ETA would not apply to this scenario number two. Okay, when it was so misconceived, such misconception led to enactment of this new provision, section 12/1. Okay, according to 12/1. Okay, I'm not going to go through the exact wording now. Okay, but in essence, it just say that, well, when we deal with the situation where a document or information, is subsequently transformed into a data message, then the provisions of the ETA will also apply. Okay, but simply what I said in the new section 12/1 here is that the provisions of the ETA also apply to the scenario in which transactions are made in a paper form at the beginning, but the paper documents are later transformed into documents or into data messages. Okay, in fact, in reality, there is no need at all. There is, in fact, no need to to have this new provision. Okay, why so? Because in fact, the ETA, every provision of the ETA apply to both scenarios. The scenario where a transaction is made in the form of a data message right at the beginning, and the scenario in which a transaction is made in a paper form at the beginning, and the transaction has been later transformed into a data message. So the ETA applies to both scenarios. In fact, it has been even made clear in the explanation of the Astro model on e-commerce. Remember when we talk about the provision of the model on e-commerce regarding what? Regarding the retention of documents. Remember, I have told you already that you may retain your information in the form of a data message, and the model law requires you to retain it either in its original form or in the form in which the information can be displayed accurately. Remember that when the model law gives you the choice that you may choose the method whereby your data message is your information is retained in the form which, even though not in its original form, but in the form which can display the content or the information accurately. That is the way to respond to the case of digitization. Okay, the case where people may just make transaction in a paper form like this at the beginning, and later they just convert or transform paper into a data message. I have explained to you already that sometimes when we transform the paper into a data message, let's say that we just get this paper scanned. Sometimes the software may change. Let's say that the fonts, but even though the font is changed from one font into a different font, the contents remain the same. in that case, it is also fine, because I mean the monologue allows us to, to retain documents in the form of a data message. Okay, provided that the method which we use, I mean, for retention, is able to display the information accurately. Okay, so when the monologue say that, well, we can just use this method, the method which can display, the information accurately, even though, the font may be changed. Okay, that means that implies that, okay, the monologue foresee that, that the use of the data messages may be into scenario, including the scenario in which, okay, transactions may not in the form of data messages in the first place. The transactions may be made in a paper form, but later, the paper document is transformed into a data message. Okay, so it is clear from the explanation, okay, in the explanation of the monologue on e-commerce, that the e-commerce law, in the in many countries, okay, they have the ETA, which are made along the line of the e-commerce law prepared by Untitled. Okay, it is clear that the monologue on e-commerce, or the ETAs of different countries, including this country, will apply to both scenarios. But okay, at the time when Thailand's ETA was amended by the ETA Act number 2, it was felt that the ETA would apply only to the first scenario, not the second one, not the scenario where your transactions are made in the paper form, the normal paper form, okay, but the paper is later transformed into a data message. Okay, so when it is misconceived like that, okay, then section 12/1 is put forth, right? As I have said, okay, in fact, there is no need at all. No need to have this new provision, which has now emerged as section 12/1. Okay, we do not need the new section 12/1, which say that the provisions of the ETA will also apply to the case of digitization like this. Okay, the case of conversion of paper into a data message, simply because it has that consequence. It goes without saying, no need for 12/1, because the ETA applies to both scenarios. Okay, so when it was misconceived, okay, that way, okay, then the law drafter just put forth the new 12/1, and you may say, well, fine, even though that it seems to be the misconception, okay, but there is nothing wrong to have the new 12/1, which announces that the ETA will also apply to the case of digitization. Okay, nothing wrong here, even though it is redundant, but nothing wrong. But if you look at the wording of 12/1 here, you will see that there is something wrong. In fact, there are a couple of things wrong. The first thing is that, okay, according to 12/1 here, according to section 12/1, if you go and have a look at this one, the provisions of section 10, section 11, and section 12 of this law, okay, shall also apply to the case of transformation, okay, of documents, normal documents, into a data message. Why on earth? Why on earth did the law drafters say, okay, that the ETA would apply to the case of digitization, okay, the case of transformation of paper into a data message, okay, only in relation to only 3 sections, section 10, okay, section 11, okay, and section 12, okay. Why on earth is the application of the ETA limited, okay, why on earth is the application of the ATA, okay, in regard to digitization, okay, limited to only section 10, section 11, and 12. Why on earth the ETA applies to the case of digitization, okay, only in relation to 3 sections, 10, 11, and 12. Why not also, section, let's say, why not also section 8? Why not also section 9? Remember we talk about section 8 in the ETA. Section 8 is about what? It's about the requirement of writing or written evidence. Section 8 allows us to use a data message to make, a transaction, okay, when the law requires that transaction to be in writing or to be supported by written evidence. The law regards a data message as writing or as written evidence. And section 9, it is the section on what? It is a provision on signature. Remember, where the law requires a signature of any person, and the use of an electronic signature will be regarded as a normal signature in the eyes of the law as well. Okay, so why did not the law drafter also say in section 12/1 that the all provisions of the ETA apply to the case of transformation of paper into data messages? Okay, why limit the application of the ETA, okay, in relation to digitization, okay, to only section 10, 11, and 12? Why not also section 8? Why not also section 9? Why not all provisions of the ETA? Okay, it is unexplainable. Let's suppose that now, again, I have this paper contract. Let's say that you and me, okay, I am A, you are B. A and B make a loan agreement according to the law of Thailand. Okay, if you make a loan agreement, okay, if you make a loan of money for a sum exceeding 2,000 baht, then the contract is required to be supported by written evidence. Okay, let's suppose that both of us just made this contract in the paper form like this. This is the contract. This is a loan agreement between us. We have made this loan agreement in a paper form. Okay, later, I have implemented, the paperless policy. Under this policy, I have now, converted all paper contracts into Commodify. I may, for instance, scan this contract, the paper contract, into a PDF file, and now, I have a PDF file on my computer, on my server, or on iCloud, okay, on let's say Google Drive. Okay, and I have discarded this paper contract because I don't have any place to keep this contract, the paper form contract. I have thrown this away. So now I have just, PDF files containing all the contracts at my company. Okay, now I want to sue the borrower because some of the borrowers have not just returned money to me. So now I want to sue borrowers. The law says that if I want to see barriers, I need to have first written evidence in support of my contracts. Secondly, I need to have signatures of the borrowers. Okay. So when I do not have paper anymore, I have converted or transformed paper into data messages, i.e., in this case, PDF files, which are stored on my computer. Can I just say that all those PDF files constitute written evidence in support of my loan agreements? Okay, then if I want to bring legal actions against borrowers, okay, can I just say that, well, Your Honor, the court, can I just say to the court that, well, Your Honor, these are all the PDF files containing my contracts. Okay, I now do not have paper anymore because I have converted or transformed paper into data messages, okay, in the form of the PDF files, which are now stored on the computer, okay. But these files, all these files constitutes written evidence supporting my loan agreement, okay. Well, the court will say this, because the court will say this to me, because they, well, okay, in your case, you just made this contract in a paper form, correct? Yes. And you subsequently transform all the paper contracts into data messages, correct? Yes. Okay. Do you know that in your country, in Thailand, it has been found that the ETA would not apply to the case of, the digitization, okay? The case of transformation of paper into, data messages later. So that you, in your country, your legislature just puts forth the new section 12/1, which allows the ETA to apply to this scenario, the scenario of digitization, the scenario involving transformation of paper into data messages. But don't you remember that according to section 12/1 in your own ETA, it says that only 3 provisions, section 10, section 10, section 11, and section 12 will apply to this scenario, okay? Okay. Section 12/1 does not make any mention of any other provisions. Section 12/1 does not make a mention of section 8 or section 9. That means that, okay, in the case of digitization, or in the case of transformation of, the paper into data messages, okay, you cannot apply the ETA to this scenario in relation to the contracts which are concerned with section 8 or section 9, okay. Section 8 is a section on writing or written evidence. Section 9 is the provision on signature, okay. Again, your section 12/1, yes, correct, 12/1 say that only 3 provisions in the ETA will apply to the case of digitization, okay. Section 10, 11, and 12. 10 is about original. 11 is about admissibility of data messages into evidence, and 12 is about the retention of information in the form of data messages, remember. Okay, so in this case, when you make this contract in the paper form, and you convert or transform your contract into a data message, okay, you cannot make use of section 12/1 because it does not include section 8 and section 9. Okay, so in this case, that means that the ETA does not apply to your case because your contract has been transformed into, your paper contract has been transformed into a data message, okay. But in this case, sorry, you cannot just come to this court because the ETA of Thailand say that in the case of digitization, okay, the only section 10, section 11, and section 12 of the ETA will apply to the case of digitization, okay. All other sections, all other provisions of your ETA do not apply to the case of digitization, okay. This is something weird. It cannot be explained that why, okay, section 12/1 only say that only section 10, 11, and 12 of the ETA applies to the case of digitization, okay. Then why not also other provisions as well? This is something very weird. So when section 12/1 says something like this, okay, right now, okay, we have the wording of section 12/1 like this. Okay, we will, come across absurdity that, okay, the paper contracts which are transformed into commodifies or into data messages may not be enforceable, if those contracts are concerned with what? Are concerned with the requirement of writing or written evidence, or the requirement of, of the, let's say that of the signature, simply because Section 12/1 does not include the application of Section 8 or Section 9 as well. Okay, this is something very weird. And when the unfortunate results are like this, it's going to have negative effects on commerce. Right. So this is something which the law drafters need to realize now. Okay. So I don't know whether the legal practitioners or the members of legislatures, they are aware of this absurdity. Okay, maybe not. Right. So this new Section 12/1 should be crossed out. It should be deleted. Why so? It should be repealed simply because there is no need. There is no need for it. The ETA or provisions of the ETA apply to both scenarios. Scenarios in which transactions are made in the form of a data message in the first place, and the scenario in which a transaction is made in the form of, in a paper form, and later, has been transformed into a data message. So there is no need for 12/1. Okay, so we have to cross this out. Okay, the second absurdity is this. The second aspect of absurdity is this. Okay, as I have mentioned, that the lawmakers in the country do not seem to appreciate this kind of absurdity at all. Okay, now coming to the second aspect of absurdity, if you go back and have a look at what is said in Section 12/1 in paragraph 2, it says that the preparation or transformation of a document and information into the form of a data message under paragraph 1 shall be in accordance with the rules and procedures, the rules and procedures, prescribed by the Commission. The Commission here, it is the Electronic Transactions Commission, which has been established under this Act. Put simply, if you want to convert paper into a data message, then you will have to follow the rules, made by the Commission. Now today, the Commission made the rules and procedures for digitization. It has, those rules and procedures now are contained in the notification of the Electronic Transactions Commission. On the rules and procedures for preparation or transformation of information into data messages. What is wrong, what is absurd in this notification is that the rules and procedures which have been established by the Commission here, they are so detailed and so technical, that that private individuals or even SMEs are not in the position to follow. Those who can follow these rules, those who may follow, those who are in a position to follow the rules and procedures established by the Commission are only large corporations. If you look at the rules and procedures here, the rules and procedures include what? Include the rules about what? About the recording of metadata. The rules and procedures in this notification also required the designation of persons in charge of different processes. The rules and procedures in this notification also say something about security procedures, which cover identification or and authentication, also authorization and accountability. Okay, we just look at the simple case of what? The simple case of the using sort of the scanner like this. Let's say that we as private individuals or as those who run SME business, we may just convert paper into computer files. We may use just a simple process using the scanner like this. We can just feed paper documents, let's say the paper contracts, into the scanner, and then the scanner will just convert paper content into PDF files, and then you may just retain all those PDF files onto your computer or onto your server. Okay, so if you just follow this simple process like this, you will not be able to observe the rules, okay, in this notification, okay, because you simply do not have all the procedures. So, right, remember that we have to recall that ETA applies to everybody, okay, including the private individuals, including the natural persons, including also corporations or legal entities. Okay, so when the law, the notification here requires something too technical that it is not able to be complied with, then the result would be what? The result would be that is a way to prevent the use of electronic means, rather than having the law promoting e-commerce or promoting e-transactions. It turns out to be the law which impedes the use of electronic means in making transactions. Okay, so this is something very, very weird. So I have the request that this provision of section 12/1 be all deleted. Okay, if we have deletion of this provision, okay, the consequence is just that every provision, all provisions of our ETA apply to cases, the case where people make transactions in the form of data messages in the first place, and the case where people make the transactions not in the form of a database in the first place. They make transactions in a paper form in the first place, and they just transform the normal documents into data messages later. Okay, so that is something which should be in this country, but unfortunately now, okay, we run into trouble, okay, great trouble, because of the presence of section 12/1 here. Okay, so please, our legislature, please just delete this provision of law, section 12/1, in order to get rid of all the absurdity which has the plague, okay, which has been surrounding our ETA for many years already now. Okay, now that we are moving forward to the one thing, okay, before we just have a break. Okay, the use of electronic stamp duty. Okay, right. Well, in this country, as with many other countries, some law requires some documents or some instruments to be affixed with stamp duties. You are required by law to affix stamp duties. Okay, it is one form of tax, but it is called duty. Okay, stamp duty. Okay, let's say that if you want to make, let's say, a contract of what? If you want to make a contract of guarantee, a guarantee agreement. Okay, if you want to initiate legal actions based upon that guarantee agreement, you are required to just affix stamp duties on your guarantee agreement. Okay, so normally we have paper form stamp duties. It's look like normal stamp. When you just when you post your letter, you have to affix your stamp. Okay, stamp duties the stamp duty in the paper form, they look like normal stamps which you use when you just post your letter. Okay. Now the question arises as to whether or not we can now resort to e-stamp duty. Okay, in place of paper stamp duty. Can we just switch from paper stamp duty into e-stamp duty? Well, the answer should be yes. Otherwise, it's going to be impediment to trade and business. Correct. So in this case, the ETA, the ETA also contains a provision, okay, which allows the use of stamp duty. Okay, if you look at, section 8 in the last paragraph, it said that where the law requires a stamp duty to be fixed, if payment has instead been made by an electronic means under the rules and procedures prescribed and published by a state agency concerned, it is deemed that the writing, the writing to which is in essence a legal instrument has been duly affixed with stamp duty. But simply what he said is just that, where the law requires you to, to just affix a stamp duty, you're welcome, to use an electronic mean, to pay the stamp duty, so, but you need to follow the rules and procedure as prescribed by a state agencies concerned, Now, we have in this country the Revenue Department in charge of, tax. We have the Revenue Department in charge of collection of tax, including stamp duties, Now, in the Revenue Department, it authorizes, it empowers Director General of the Revenue Department to issue notification, prescribing procedures for payment of duties. Now, the Director General of the Revenue Department has issued the notification, prescribing procedures for payment of duties in a monetary form in respect of electronic instrument. I do not have the English version here. I just give you a look, a look of this notification. This is how this notification look like. This is what this notification look like. So according to this notification of Director General of the Revenue Department, the number 58, we have the notification of the Director General of the Revenue Department, the on stamp duties number 58, right, which has been amended by by the notification on the same matter number 59, right. According to this notification as amended, right, it allows all these instruments. It allows 1, 2, 3, 4, 5 instruments to be affixed with e-stamp duties. You may wonder why not all instruments? Well, because maybe the Revenue Department is not yet ready to allow the e-stamp duty payment. They're covering all instruments, and now we start with this 5 instrument: the hire of a contract, loan or bank overall agreement, power of attorney, proxy document for voting at a company's shareholders meeting, and a guarantee. If you just make these 5 instruments, any of these 5 instruments, you don't need to affix stamp duties in paper form. You may use e-stamp duty, electronic stamp duties. How do you do that? Well, the Director General has prescribed the form, the e-stamp duty form. In time we call this one also 9, the also 9 form, okay, you may just pay stamp duty through two channels. You may just pay e-stamp duty through the Revenue Department website. Go to www.rd.go.uk in the same way as when you want to pay tax online. But in this case, you do not want to pay your personal tax. Okay, you want to just affix e-stamp duties on the instruments which are allowed by law to be affixed with e-stamp duties. Okay, you may go to this website in order to make payment, okay, online. Okay, or you may use the API application programming interface, okay, of the department. You may just undertake everything by yourself, or you may just use service of a provider. Fine. So there are two main channels. Okay, the website going to making use of the website of the department, or making use of the API launched by the department for the purpose of fixing e-stamp duties on the instruments allowed by law to be fixed with the e-stamp duties. Okay, this is the website of the department. Okay, you may just of course you need to get your ID, user ID and password. You have to apply for this. It's the same thing as it look like something the same as what? The same as when you pay your personal income tax. Okay, you go to this kind of thing as well. You need to use your ID, you need to use your password. Okay, and when you want to affix e-stamp duty, how do you make payment? You need to make payment via money transfer to the Revenue Department's bank account. Okay, there is facility for you to transfer money from your account to the account of the department. When you have completed your payment, then you will be supplied with what? You will be supplied with the stamp duty payment acknowledgement code, something which look like this. Okay, this is evidence that you have made payment of stamp duty in an electronic form, or in other words, you have affixed stamp duties, okay, e-stamp duties. Okay, so you can download this stamp duty payment acknowledgement code. Okay, if you just use the website, you can download it through website. If you just use the API, then you can also get this code via the API. Okay, this is something new. Okay, this is an innovation put forth by the Revenue Department. Okay, so I believe that this is something which makes your life much easier. Okay, so that's it for the today. Okay, we have gone through all key provisions of the ETA. Okay, again, you have seen that these key provisions of our ETA are drawn from what? From 11 provisions of the model law on e-commerce, and also 11 provisions of the model law on electronic signatures prepared by Unsutro. Okay, so I encourage you to also have a read of the guide to enactment to this model laws. Okay, in order to understand Thai law as well. In this country, not many people have proper understanding of provisions of the ETA. So I think that time is right for you to establish, to build up your proper understanding of key provisions of the ETA. Okay, in fact, the ETA also contains provisions regarding how to make contracts electronically. Okay, we are going to go through the second part of of this course. Okay, on this topic, the part regarding electronic contracting. Okay, but I'm going to just defer this explanation to next time. Okay, because now that we feel that we just become tired. Okay, we have the lecture for about 1.5 hours, okay, approximately, so that, okay, that we are going to have the second part of this lecture next time, okay, maybe tomorrow, okay, that as a supplemental lecture, okay. So until then, thank you very much for your attention, okay, and see you tomorrow, okay. Thank you very much. Thank you. Good day.